Okay, so probation of offenders, we were discussing last class that
Yes.
rather than sending them in prison, we should try to see if there is any alternate way, right, of releasing the person with a warning, or maybe by signing a bond of good conduct, can we release the person or not? In such a case,
Yes.
again, supervision may be there. Even though they are released, they are not like a completely free, but some supervision might also be there on them. And if they are found to disobey any of the conditions in the bond or something they are doing against it, then they may again be arrested as well. They may again be given the punishment also. Right, so regarding this, we will. So one provision that we have is variation of conditions of probation. So now probation officer would submit some reports, right? Some investigation will be done that what is the history of this person, what is the kind of like character of the person, social background, all those things would be taken into consideration, right? And probation officer will submit a report that this is what we have found about the social background of the person or criminal background of the person, right? So that certain report is considered as confidential, that it's only something which the court would take into consideration. It's the confidential information. But if the court is of the opinion that something is needed, okay, it may communicate substance thereof. As such, the report would not be provided, but what's mentioned there, maybe some points, some clauses, etc. They can communicate substance of it to the offender and may give him an opportunity of producing such evidence as may be relevant. So they might ask, court may ask that, okay, this is what we have found in the probation officer's report. What do you have to say about it? Do you have any evidences to support your argument? Like that, it may be informed to the person, which should be just like a communication, not like the copy of the report would be submitted. Okay, now variation of conditions of probation. A person was released on probation and there were certain conditions, might be that you need to maintain good behavior, you should not be like any intoxicating drinks or anything you should not consume, you should not create any kind of public disturbance, like that. There may be many conditions or grounds, right? So when we say variation of conditions of probation, that means on whatever conditions he was given probation, there are some changes there. Okay, there are some variations there. So when an offender is released on probation of good conduct, that you need to maintain good conduct, these are the things that you should follow, and he was released on that. The court which passed such an order may make changes in the bond on application of probation officer. Maybe a probation officer was monitoring the person, observing the person, and probation officer found out that, okay, fine, what he is doing is he is doing this certain thing, and maybe that kind of a provision was not mentioned in the bond. Okay, maybe that he was having intoxicating drinks and he was not like creating disturbance as such, he was not fighting with anyone, but maybe on roads he was creating some drama and stuff. Their probation officer might inform the court that otherwise fine, you are releasing the person, but he is doing this certain thing. Okay, so their court may make some changes in the bond application, in the bond, that this is also what you need to maintain. Okay, it may be based on the application that probation officer may give. Such changes can be made at any time during the period when the bond is effective. If the bond was for 1 year, within 1 year, those changes can be made. If the bond was for 3 years, within 3 years, it can be made. But it cannot be made after 10 years, 20 years, when already this bond validity is over. Okay, until the bond is valid, changes can be made. However, the duration of the bond shall not be extended beyond 3 years in any case. That was a limitation, which we saw in that other topic also, probation on bond of good behavior. There also we have seen that maximum for 3 years, they can ask the person to sign a bond. So it should not exceed 3 years in any case. While making changes in the bond, the offender and the surety or sureties mentioned in the bond must be given an opportunity of being heard. It's not that only based on whatever probation officer is saying, court would straight away make changes, but they also would be given a fair opportunity of being heard. What the offender has to say, what his surety or sureties has to say, those also court will hear. Okay. So this is variation of conditions of probation. If the court wants, they can make changes and it would be done by the same court which released the person on bond of good behavior. Procedure in case of offender for failing to observe conditions of bond. This is maybe some points were missing or something, and probation officer feels that this certain condition also should be put, right? And their court has made the changes, court can make additions. Now, procedure in case offender fails to observe conditions of bond. Something was written in the bond and the offender fails to fulfill that. He does something against it. In such cases, what process will be followed? Okay, if the court which passes an order for probation on good behavior is of the opinion, maybe court has only itself found something, or might be probation officer has given some notice, or maybe some other person has informed about it. Okay, whatever might be the mode how court came to know, but if court is of the opinion that this person who was released on offender, the offender has failed to observe any of the conditions which was mentioned in the bond entered by him. He did enter into a bond, but now he failed to perform or fulfill the obligations. It may issue a warrant for his arrest and may, if it thinks fit, issue summons to him and his sureties, if any. If court says that, okay, he is creating like too much of problem in the public places, he's fighting with people, causing this, that, in such a case, court may straight away issue a warrant that arrest this person. He is not fulfilling the conditions at all. Okay, but it might be something like a milder version. He is just not following some conditions, or maybe probation officer has informed the court that this certain thing he is not following. In such a case, rather than straight away arresting the person, court may issue summons that you need to appear before the court on so and so date, or maybe his sureties may also be summoned, that you had given a surety that he would maintain good behavior, now you also come before the court. If any, requiring him or them to attend before it at such time as may be specified in the summons. Court would mention on so and so date you come, appear in the court and give your point of view, because we have got this kind of an information that you are violating the conditions which are there in the bond. The court before which an offender is so brought or appears, it may be that arrest warrant was issued, police arrested him and produced him before the court, or might be that he himself appeared based on the summons. Okay, may either remand him to custody until the case is concluded. Court might say that, okay, we are deciding on this matter, whether this information is true or not, whether he has actually violated the provisions or not. So keep him in custody so that he did not escape or something, keep him in custody. Or it may grant him bail also, or he may be released on bail with or without sureties to appear on the date which may be fixed for next hearing. It depends on court, just like how a normal procedure goes, same way court can deal with this matter as well. Now, if the court after hearing the case is satisfied that the offender has failed to observe any conditions of the bond that he entered, that after hearing the case that yes, it is true only, this person has failed to observe the conditions, he did sign on the bond, but now he is not observing. What will court do in that case? Sentence him for original offense. Otherwise, what he would have got, right? That same punishment may be given. Okay, 6 years, maybe cheating case up to 7 years, maybe 5 years punishment might be given. Or where the failure is for first time, Otherwise, he is a good person only because of some mistake once he fails to fulfill the bond conditions. Then in such case, what happens is continue in force, impose on him penalty. Some penalty may be imposed, just like a warning that, okay, if you are doing it next time it would be more severe, right? So for that time, penalty may be imposed. And if penalty is not paid, penalty was imposed, court did not sentence him to for the original offense, but court simply imposed penalty because it was first time. But he failed to pay the amount within such period as the court fixes, then the court may sentence the offender for original offense. That first of all, you violated the bond that you had signed. Secondly, you are not paying the penalty also. So rather than releasing you, we should give you this only. So court may again decide this, that you are not following directions of court, so rather you get the punishment only. Like that also court may do. Okay.
Yes.
Now we are talking about probation officers here and there. So who is probation officer? Probation officer is any person appointed as a probation officer by state government or who is recognized as a probation officer. Might be he was into some different position or some different work, that he is recognized that, okay, you are also having the power of a probation officer. That person is a probation officer. A person provided for this purpose by a society recognized in this behalf by the state government. Someone who is recognized, that also would be included. And in exceptional cases, any other person who, in the opinion of court, is fit to act as probation officer in special circumstances of the case. For some specific matters, if someone is given the authority or power, that person can be considered. Basically, whoever is performing this task, they only would be probation officers with the authority of government.
So he need not be a government employee.
No, he would be a government employee ideally. But in some exceptional, some rare situations, if court feels that, okay, might be a government employee would not be able to, observe this person, whether he is fulfilling the bond or not, someone may also be given. Okay, ideally, he would be someone who is appointed as a probation officer itself. Sometimes it may be a different person also. In exceptional cases, court is basically given the liberty that it can appoint that, okay, you are the one who will have to supervise this certain thing. Okay, so recognition should be there, recognition from the government, and we would say this person is a probation officer. A court which passes an order under section 4 or the district magistrate of the district in which the offender for the time being resides at any time, appoint any probation officer in the place of the person named in the supervision order. For the purpose of this section, precedence term shall be. So someone may be appointed that, okay, you need to keep an eye on this particular person. Okay, you need to see that these things are being properly followed. Whatever he has promised, basically, right, those things are being followed, so you need to do that. When a person is released on probation of good conduct, along with that, a person may also be given the authority that you need to supervise. You need to see this person is following the terms or conditions. A probation officer in the exercise of duties under this act shall be subject to control of district magistrate of the district in which the offender for the time being resides. Wherever the offender is residing, their district magistrate would have control on the probation officer. He will be observing what the person is doing. Okay, now there are certain duties of this probation officer. There are not like a lot of duties, but some duties are there. So he needs to inquire into the circumstances or home surrounding of a person accused of an offense with a view to assist the court in determining the most suitable method of dealing with him and submit the report. Whether we can release this person on probation, on bond of good behavior or not, those they would inquire. So basically they will inquire, taking into consideration the existing circumstances, home surrounding, and the kind of environment from where the person belongs, and submit a report to the court. supervise probationers and other persons placed under his supervision and where necessary endeavor to find them suitable employment. They would observe these persons. Sometimes it may happen that this person is an unemployed person. Because of the situation, he ended up committing a crime. So court might help them in finding some kind of employment also, so that they can remain or they can maintain good behavior, they can follow the conditions as well. So inquire into the situations, supervise probationers or other person, advise or assist offenders in payment of compensation or cost ordered by court. Maybe case was filed, court found out that this person is guilty, but even then he was released on probation of good behavior. But court may ask them to pay some compensation or cost, right? You need to pay compensation to the victim, or you need to pay the cost for filing of the case. In such cases, probation officer would also help them how to clear all this compensation, cost, etc. There also they would help. Advised and assist in such cases and in such manner as may be prescribed person who have been released under section 4. If a person was released on bond of good behavior, some advice, assistance, whatever is needed, that also they will do. Perform such other duties that may be prescribed. Anything else is needed means that also they will perform. Okay, so these are the main functions that they will basically help that person remain or maintain good behavior. If he needs any kind of support on how to pay the cost, compensation, how to deal with the matter, there also some help or assistance would be given. He is basically like a communicator between the offender and the court, right? Now, probation officers to be public servant. This is very important. Okay, when we talk about public servant, they do get a lot of immunities. Okay, public servants get a lot of immunities. So it's very important that these kind of officials are considered as public servant when they are performing their duties and all. If they are, if somebody disturbs them, somebody creates any kind of disturbance, that is like a major offense under IPC. Okay, same ways you cannot straight away file a civil case against them. Okay, if the offender feels that this person has violated my rights or something, straight away he cannot file a civil suit. He needs to give an information, he needs to wait for 2 months. Like that, a lot of immunities they get. Okay, so they would be considered as a public servant. Yeah. So that they can, this is only because they would be able to perform their functions properly. Okay, when if they want to visit someone's house or do inspection or something for the inquiry, they cannot be straight away restricted that who are you, how come you are here, we would not let you enter. He can say, I'm a public officer, I am performing my duty, so you need to help me. Like that also it can happen.
Yes.
Protection of action taken in good behavior. Now, no suit or other legal proceeding shall lie against the state government or any probation officer or any other officer who is appointed under this act in respect of anything which is done in good faith, okay, or intended to be done in pursuant to the act. But they thought that, okay, we are performing whatever we are duty bound under this act, and in good faith they are doing it. In such a case, you cannot file a case or a legal proceeding because they were performing their functions. Okay, they are getting some immunity also. Protection of action taken in good behavior. Okay, so these are the sections which we have under this legislation, which are like important ones, right? We have total 18 sections, so till 16 it is important. Is this part clear?
Yes, madam.